In this session, we are going to be speaking with Nathan Ben-Key, Regulatory Compliance Advisor at Cornerstone Credit Union League, and he's going to talk about the OFAC compliance requirements. So first, Nathan, what is OFAC?
Sure. OFAC stands for the Office of Foreign Asset Control. OFAC is a division of the U.S. Treasury Department which administers and enforces economic and trade sanctions based on U.S. foreign policy and national security goals. OFAC maintains a list of individuals that U.S. citizens are prohibited to conduct transactions with. All bank regulatory agencies and the National Credit Union Administration cooperate to ensure compliance with OFAC.
Okay, so speaking broadly, what does a credit union need to be doing to be compliant with OFAC then?
Every credit union is expected, both by OFAC, state regulators, and the National Credit Union Administration, to establish and maintain an effective, written OFAC compliance program appropriate to the credit union's risk profile. The first step in OFAC compliance is developing an OFAC risk assessment. Appendix M to the FFIEC's BSA AML examination manual is a great resource to get you started on your OFAC risk assessment. A risk assessment should consider all of the credit union's operations. This includes the type of transactions and transaction parties, resources, both staff and technology, and the geographic risks to areas that are serviced by the credit union. A good way to frame OFAC compliance is to ask, which areas of the credit union's operations create the most risk for an OFAC violation, and how will we work to mitigate that risk?
So, for example, wire transfers and foreign transactions, do you mean?
Yeah, sure, Simon. Those are a given. We're also talking about opening new accounts, payments to non-members, and beneficiaries. A credit union should also look at other areas to determine risk, such as the kinds of products and services the credit union offers, the field of membership, the number of members, asset size, and the credit union's general geography and branch locations.
Who must comply with the OFAC guidelines then?
All U.S. citizens, businesses, and financial institutions operating under U.S. jurisdiction. OFAC covers everyone. Everyone has a duty to prevent, block, or freeze transactions against those OFAC designates as prohibited parties.
How does a credit union fulfill its duties with regard to OFAC?
First, by creating an OFAC policy. The policy needs to be approved by the board and be in line with the credit union's risk. This policy needs to be reviewed on a regular basis and at least once a year. Similar to the BSA compliance program, the credit union's OFAC compliance program needs to identify high-risk areas such as wires, cross-border ACH transactions, and other sorts of transactions. Provide for appropriate internal controls for screening and reporting. Establish independent testing for compliance. Designate an employee or employees as responsible for OFAC compliance, and create training programs for appropriate personnel in all relevant areas of the credit union.
How does OFAC designate a party as prohibited, for example?
OFAC maintains two main lists of prohibited individuals. The first is the Specially Designated Nationals, or SDN list, and Blocked Persons list. These lists are updated on a regular basis, but by no particular schedule. OFAC also maintains a second list, the Palestinian Legislative Council list, or PLC. Similar to the SDN list, the PLC list is a separate list that transactions must be reviewed against for prohibited parties. Individuals on these lists are those that were elected on a party slate of a foreign terrorist organization, specially designated terrorist, or specially designated global terrorist list. Transactions involving these individuals must be blocked as well.
What is blocking?
Blocking, also known as freezing, is a form of controlling the accounts and other property of any country, entity, or individual under U.S. jurisdiction appearing on OFAC's SDN list or PLC list. Blocking immediately imposes an across-the-board prohibition against transfers or transactions of any kind with regard to the property. A credit union may also be required to reject a transaction, and I'll explain that here in just a second.
So Nathan, moving forward, what happens when a credit union finds a match, let's say?
Once a potential match is found, the credit union needs to do a little more research. Is it an exact name match? Is it close? Is the customer located in the same general geographic area as the SDN? If not, the match might be a false hit. If you're not sure about a potential match, you can always call OFAC at 800-540-6322. If you do have an exact match, you are required to block or freeze the property and any payment of any funds transfers or transactions, and report the block within 10 business days of the occurrence. Some OFAC-administered programs require blocking or freezing of assets, while others just require rejecting the transaction. Blocking means that the credit union should accept the funds and freeze them so that the individual or entity cannot obtain or recover possession of the funds. OFAC regulations require that these funds earn interest at a commercially reasonable rate. Rejecting a transaction means that the credit union simply returns the funds to the sender. In some cases, an underlying transaction may be prohibited, but there is no blockable interest in the transaction. So instead of freezing, the transaction is just not processed. If a credit union has a question about this, they should call OFAC. As an example, a U.S. bank would have to reject a wire transfer between two third-party companies that are not on the SDN list if the transfer involved an export to a non-SDN company in Sudan. Since there is no interest of the government of Sudan or an SDN, there is no blockable interest in the funds. The U.S. bank cannot process the transaction because that would constitute a transaction in support of a commercial activity in Sudan, which is prohibited by the Sudanese sanctions regulations.
To what kind of property does an OFAC rules apply?
OFAC defines property broadly. Anything of value is property. These include, but are not limited to, money, checks, drafts, debts, obligations, notes, bills of sale, evidence of title, negotiable instruments, contracts, and anything else real, personal, mixed, tangible, or intangible. These include interests or interest therein, present, future, or contingent. Pretty much everything credit unions do every day fits under the definition.
So Nathan, so if this can involve any kind of property, wouldn't this touch pretty much any kind of transaction?
Absolutely, Simon. OFAC regulations are broad enough to involve any transaction that might involve a specially designated national, PLC, block person, or block country. Not just international transactions. Terrorist funding often runs through our own domestic institutions. OFAC compliance touches everything a credit union does, and every process, such as opening new accounts, wire transfers, ACH transfers, electronic fund transfers or EFTs, cashing or depositing share drafts and checks, the purchase of money orders or cashier's checks, dispensing loan proceeds and accepting loan payments, safety deposit boxes, and trust accounts. All these transactions must be checked for possible matches.
So Nathan, which parties are on the transaction?
All the parties on the transaction. Primary members, joint account holders, co-signers, guarantors, collateral owners, beneficiaries, parties on both ends of a wire transfer, payees on a check, anyone that touches, benefits, or is a party to the transaction in some form. They must all be checked against these lists for a possible match.
So, what other ways does a credit union need to be OFAC compliant then?
There's several ways. Credit unions need to check their entire membership list against these prohibited lists on a regular basis to ensure that the credit union doesn't do business with a prohibited individual. These lists change without notice, so a credit union will need to consider its risk assessment when determining how often to review the list. Credit unions also need to check names before individual members perform certain transactions, such as opening a new account or transferring funds via wire transfer or other means. OFAC screening should also be part of the screening of new members and as an essential part of any member identification program or due diligence procedure. New accounts should be compared with the SDN and PLC lists prior to being opened or shortly thereafter. Keep in mind that it is illegal to do business with any OFAC prohibited party, and any account screening process must check for match before the account opening process is completed. This includes any beneficiaries to an account prior to opening an account. It is OFAC's opinion that even the designation of a beneficiary on an account card is considered a future interest, and therefore credit unions need to check account card beneficiaries at the time the beneficiary is added to be considered compliant. Appendix M of the FFIEC manual states that the extent to which the credit union includes account parties other than account holders, such as beneficiaries, guarantors, principals, beneficial owners, directors, signatories, and powers of attorney, in the initial OFAC review during account opening process and during subsequent database reviews of existing accounts, will depend on the credit union's risk profile and available technology. To plug interdiction software a bit, we strongly encourage the use of such software in high volume areas where human error is more likely to play a factor, or where the risk of prohibited transfers is traditionally higher. This can include account opening, wire transfers, funds transfers, and remittances.
So what if a member has a legitimate reason for sending funds to a prohibited party, let's say? Are there any exceptions to the rule?
Any person having an interest in doing a block transaction may file an application for an OFAC license authorizing the transaction. OFAC's licensing division provides general and specific licenses to authorize certain transactions that otherwise might be prohibited. Without a license, a credit union cannot release funds.
Nathan, you mentioned that reports are due within 10 business days. What is to be reported in that report?
Depending on whether the transaction is blocked or rejected, the report needs to have different information. If a transaction or account is blocked, the blocking report must identify the owner or account party, a description of the property's location, any existing or new account number or similar reference necessary to identify the property, actual or estimated value, the date the transaction was blocked, a photocopy of the payment or transfer instructions, documentation showing that the blocked funds have been deposited into a new or existing blocked account which clearly identifies the interest of the individual or entity subject to blocking, the name and address of the credit union as the holder of the account, and the name and telephone number of a contact person at the credit union from whom compliance information can be obtained. If the transaction is rejected, the report must include the name and address of the transferee financial institution, the date and amount of the transfer, a photocopy of the payment or transfer instructions received, the basis for rejection, and the name and telephone number of a contact person at the transferee financial institution from whom compliance information can be obtained. These reports may be submitted electronically, by fax, or by mail. Blocking and rejection reports must contain a copy of the original transfer instructions. In addition, all holders of blocked property are required to file a comprehensive annual report on blocked property held as of June 30th by September 30th each year.
How long does a credit union need to keep records for OFAC purposes then?
All OFAC record must be retained for 5 years. Records of rejected transactions need to be maintained for 5 years from the date of the transaction. For blocked accounts, credit unions must maintain records for 5 years after the date the account is unblocked. For as long as the account is blocked, a credit union is required to maintain a full and accurate record of the blocked account for as long as the credit union is holding the blocked property.
So is it possible, but unlikely, that even the best strategies might still fail to catch an OFAC prohibited transaction? Is that possible?
That's correct, Simon.
So Nathan, what are the penalties for failure to comply here?
Depending on the circumstances, failure to block and report an illicit transfer could result in civil fines or criminal penalties against the credit union and employees. Criminal penalties range from $50,000 to $10 million, and imprisonment ranging from 10 to 30 years for willful violations. Civil penalties can range from $11,000 to $1 million for each violation, not including the forfeiture of any funds or property involved in the violation.
So Nathan, where can credit unions get more information on OFAC compliance? Because this is pretty important.
OFAC's information is contained on the U.S. Treasury website at www.treasury.gov. The OFAC website has the newest recent actions and the most current SDN and PLC lists. A list of frequently asked questions is also available, listed on the website, listed here on screen. Credit unions may also call OFAC's hotline at 1-800-540-6322 and ask for a starter kit containing the Foreign Assets Control Regulations for the financial community. OFAC public information is also available via computer and the SDN and blocked persons list. The FFIEC manual also provides great guidance for complying with OFAC.